now.
Hello, and thank you for joining us. My name is David Gabor, and I'm here with my esteemed colleague, Catherine Brustowicz. Today, we will be talking about non-compete agreements. There has been a push at the federal level and in several states to sharply limit and even curtail the use of non-compete agreements. This is, in and of itself, a challenge to employers who want to protect their assets, but do not know how to avoid running afoul of the law. So essentially, we're blending best practices with compliance. And to further complicate matters, cases have been filed to challenge the FTC's final rule, and in some states, there have been challenges to their non-compete bans as well. Catherine, how are you? And please walk us through the agenda.
I'm doing well, thanks, David. Let's head over to the agenda here. Perfect. So in terms of the agenda, we're going to start off with a brief summary of the FTC's new rule. As our webinar continues, we'll delve into the various nuances and specifics. Next, we'll discuss the rule's impact on other restrictive covenants, such as non-solicitation agreements and confidentiality clauses. Third on our list is the impact of state laws on non-compete agreements. As you're well aware, state laws can vary tremendously, so this is a very important piece of information. Next, we'll review the proper steps employers need to take to notify their affected employees. Then, David is going to help us understand how to review and update offer letters, as well as specific agreements in light of the new rule. If you've ever joined us before, the last item on our agenda will come as no surprise. We like to wrap up our programs with an accessible top 10 list of important takeaways from the webinar. So, without further ado, let's go ahead and jump in and learn about this new rule. On April 23rd, 2024, the U.S. Federal Trade Commission, the FTC, approved a final rule banning new non-competition clauses in employment contracts for most workers across the entire United States. Now, I say most workers because there are a few exemptions. Certain not-for-profit entities are exempt from the final rule, though you should note that for-profit subsidiaries of nonprofit entities do not qualify for the exemption. Non-competes entered into pursuant to a bona fide sale of the business entity may also remain in place. So why did the FTC create this rule anyway? In essence, the ban stems from the FTC's view that non-competition clauses suppress wages and unfairly limit competition in violation of Section 5 of the Federal Trade Commission Act. The final rule becomes effective 120 days after being published in the Federal Register. So that brings us to September 4th of 2024 as the effective date for this rule. So with that brief overview of the rule, David, would you mind walking us through non-compete covenants in general?
Sure, thank you, Catherine. Briefly, a non-compete covenant is a provision that restricts some options that an employee has when searching for a new position. The non-compete could prevent the individual from working in certain industries. It could also have a geographic limitations, and it could also include a position about a length of time. For example, imagine a commercial real estate agent who works in New York City. The non-compete agreement may state that the employee cannot work in a commercial real estate field in any of the 5 boroughs for a period of 2 years after employment ends. That's just one example of how a non-compete agreement can work. In the past, courts would review non-competes to determine whether they were reasonable in scope. And you could be in front of five different judges in the same state and get five different rulings from the court. And in other instances, a 2-year ban might be found to be reasonable in state one, but state two might say, oh, it's way too long and it's unfair. And in some instances, the provisions would be stricken altogether. In other cases, a court might use a blue pencil to change a 2-year ban to, for example, a 1-year ban. Now, Catherine touched on a bit about how the FTC got to this point, but there are public policy concerns that need to be addressed. One of them is to make sure that employees are able to find a new job. A goal in many instances, not just with non-competes, but with, for example, the Americans with Disability Act, is get people back to work. And the concern is that a non-compete may suppress the ability of a person to earn a living. And it also has an impact on competition. Consider an employee who was terminated from a job through no fault of their own, and then is unable to find comparable work because of a non-compete provision in an employment agreement. We compare that to an employee who is leaving voluntarily. Um, so the former employee, had to sign the agreement just to get the job. And now all of a sudden, because they signed the agreement, they can't get another job. And oftentimes a person who signs an agreement thinks I can work as long as I want in this company, so long as I work diligently. And, that is a bit of the backstory on this. Another focus is the impact that non-competes have on competition. A fundamental tenet in our society is competition brings out the best in us. And we will discuss how other restricted covenants may sneak into the non-compete territory later on in the program. Speaking of competition, Catherine was a well-recognized athlete before becoming an attorney with the firm. Catherine, can you talk about exceptions on the ban?
Yes, certainly. And thank you for that, David. So we're going to go through how to identify grandfathered non-compete covenants, or as David had phrased it, which types of non-competes are exempt from this ban. So this comes down to two key pieces. One is whether an exemption to the ban applies, and the second is the date of the agreement itself. There's a grandfathering provision within the rule for senior executives. So those are workers earning more than $151,164 per year who are in a policy-making position, who have non-competes that were entered into before the final rule's effective date, which again is September 4th of this year. Those non-competes may remain in place. But it's important to note that employers may not enter into or enforce new non-competition agreements with senior executives following that September 4th date. So, David talked a little bit about public policy reasons behind this ban. So why are senior executives still, why are these agreements still enforced for senior executives? The idea is that this subset of workers is less likely to be subject to the kind of acute and ongoing harms currently being suffered by other workers subject to existing non-competes. Now, keep in mind that the new rule does not allow for new non-competes with senior executives that are entered into after the effective date. That's really important. The final rule also does not apply to non-competes entered into by a person pursuant to a bona fide sale of a business entity. So the two major exemptions here are one, senior executives, and two, those that are entered into pursuant to a bona fide sale of a business entity. And thirdly, I had mentioned this early on in the agenda slide, but I should mention again that the rule does not apply to most not-for-profits. Those typically lie outside of the FTC's jurisdiction. Jen. Let's take a look at how the rule affects the validity of other restrictive covenants, such as non-solicitation and non-recruitment provisions. Employers do have alternatives to non-competes for protecting valuable investments that burden competition to a less significant degree, and thus are in keeping with the rule. Now, rather than restraining a broad scope of beneficial competitive activity, just what David was talking about, by barring workers altogether from leaving a job with the employer or from starting a business, and by barring competing employers and businesses from hiring those former employees, these alternatives are much more narrowly tailored so that they limit the impacts on competitive conditions. Now let's take a look at what some of those alternatives are. Namely, non-solicitation, non-recruitment, confidentiality, and non-disclosure agreements. The ban does not nullify these, but only if they do not have the impact or effect of a non-competition agreement. Such agreements should be carefully reviewed to ensure that they do not have provisions that might be considered non-compete language under the final rule. Specifically with respect to non-solicitations, these are generally not affected by the ban, but again, employers must proceed with caution. If a non-solicit clause functions to prevent a worker from either seeking or accepting other work, or from starting a business after their employment ends, it would be unenforceable. Now, NDAs or non-disclosure agreements. Appropriately tailored NDAs may prevent workers from disclosing or using certain information, but they generally do not prevent workers from seeking other work or, again, from starting their own business after their employment ends. Remember, though, that a non-disclosure agreement or clause can act like a non-compete, and if that's the case, it would not be enforceable. So you have to be very careful about the language that you include and ensure that it's narrowly tailored. So by way of example, when an NDA spans such a large scope of information that they function to prevent workers from seeking or accepting other work or starting a business after they leave their employment, it operates in the same way that a non-compete does. Such non-disclosure agreements are so broadly written that for practical purposes, they essentially function to prevent the worker from working for another employer in the same field and are therefore going to be considered to be non-competes under the FTC's final rule. In a few slides, David is going to run through how to review and update existing non-disclosure agreements and confidentiality agreements. But first, let's go ahead and review the rule's interaction with state law. David?
Hey, thank you, Catherine. The final rule does address its impact on state laws, but it gets kind of interesting because the final rule expressly supersedes state law. However, if the state law is more stringent, for example, California, which I'm going to talk about in a few moments, then that law is not superseded. So let's say, imagine we have a company called Oshkosh, and they pass a law that permits employers to have non-compete agreements. And the public policy in the state of Oshkosh is for employers to have complete and total control over their employees. That law would be superseded by the final rule. California, which we'll talk about in a moment, has legislation that is more protective of employees than the federal law, and it's not superseded. By way of background, several states, in addition to California, have enacted legislation regarding non-competes. Massachusetts, for example, enacted a law, I think it was around 2017 or 2018, and that created certain requirements that an employer must satisfy before a non-compete would be enforceable. For example, that they had to disclose it at the time of offering a job, give the employee an opportunity to consider it, talk to an attorney, and they had to have consideration separate and apart from continued employment for the non-compete to be enforceable. California, which had legislation that came out about a half a year ago, it's very interesting. Presumptively, a non-compete is unenforceable. Now, what happens is in California is it applies to non-compete agreements entered into in California and agreements from other states. So, for example, you can have a company called DeLorean Drive Corp in Illinois, and they employ a fellow named Biff. And Biff has a non-compete agreement precluding him from working in the automotive field for 2 years after the end of his employment. And Biff is earning $1.21 million per year. Now he leaves DeLorean and he takes a job with Doc Brown Motors, another automotive company. This one's located in California. And McFly, the CEO of DeLorean, sends a cease and desist letter to Doc Brown Motors. So would that violate California law? Under the new legislation, it would. It's illegal to seek to enforce a non-compete agreement, even if it's entered into in another state in California. And that's where California stands on the topic. So this puts quite a burden on employers, which we're going to talk about on slide 9 in a moment. But before we get there, Catherine, can you talk a bit about the steps that employers should take under the FTC's final rule?
Yes, absolutely. And also, David, just to confirm, you were right. The new non-compete law in Massachusetts that you just ran through quickly there, that did go into effect in 2018.
Okay, I guess that's my one good nugget for today. Thank you.
Well done. So now we're just going to go through identifying the proper steps to notifying affected employees. Employers will be required to provide notice to both current and former workers. Again, this is excluding senior executives who are exempt. But current and former workers need to be notified that their non-compete clauses are no longer enforceable. So it's not just enough for the employer to recognize that they can't send cease and desist letters any longer or try to enforce these clauses. They actually have to ensure that their current and former workers who are affected are aware that that their non-competes are no longer enforceable. Employers should draft notices that, in accordance with the final rule, advise employees that they will not enforce non-competes after the final rule's effective date, September 4th. The rule itself includes model notice language, and it creates a safe harbor for employers that use the model notice. So I would advise employers to just go ahead and utilize that notice. It is available on the FTC's website, and the language is very simple. Essentially it says that there's a new rule enforced by the FTC, which makes it unlawful for us as employers to enforce a non-compete clause. And you must highlight the date and say that the employer after that date will not enforce any non-compete clause against you, which means that as of the date, which needs to be no later than the effective date by the rule. So anytime between today and September 4th, the employers can send out this notice and let the employee know that you may seek or accept a job with any company or any person, even if they compete with us. You can run your own business, even if it competes with us. And essentially, it lifts all of the previously in place non-competition facets. And it is important also in the notice to include that the FTC's new rule does not affect any other terms or conditions of the employment. And then the notice also includes a link so that the individuals are able to seek further information off of the FTC's website as well. And how should the notice be delivered? You have a lot of options here. You can either hand deliver the notice, or you can send it by mail to the worker's last known street address. You can email it, and the FTC notes that you can also send the notice by text message. So the take-home message here is that the affected employees not only have a right to be made aware of this, but it is a requirement that employers need to abide by. So this brings us up to updating existing offer letters and other agreements. David, would you like to take this slide?
Sure. Can you go back one slide real quick?
Sure.
Okay. I love when my clients document things. So if you deliver the notice by hand delivery, it's a good idea to have the employee sign or acknowledge that they received the notice. If you do it by text message, find a way to save that into the employee's personnel file, same as a record that you sent it by mail or the email that you sent uh, with the notice. Just be sure to document then and there. Don't wait 6 weeks or longer to go get around to documenting, because if you wind up in court and you don't have the documentation, a judge might conclude that you did not provide the notice. Okay, thanks. So we can go back to the next slide. Thank you.
That's a really great point, David. Thank you for addressing that.
Sure. So on this slide, we're going to talk a bit about the offer letters, restrictive covenant agreements, uh, and employment contracts, as well as arbitration clauses. Um, you've got an employee comes to work for you. They've got an offer letter. The offer letter predates our discussion about this FTC's final rule, or if you're in a state like California or Massachusetts or other states that have got non-compete agreements, it predates it. It's a good idea to go back to the offer letter and see if there's anything in that letter that speaks to non-competition. If there is, you probably would want to create a new document with that employee so that you don't have something that's inconsistent with your state or federal laws. I know this is a real pain in the neck, but it's an exercise. It's better to do it now, early on, than to be scrambling last minute to do this. Now, the different types of restrictive covenants that I've seen, either in a separate agreement, restrictive covenant agreement, or even sometimes contained in offer letters, or for that matter, employment contracts, could be a non-solicitation, confidentiality, a requirement to return all property at the end of employment. Uh, these are important provisions that protect the employer, and we've recognized how important it is to protect you so that you can run your business without unfair competition. Um, Non-solicits generally are safe, but be very careful to ensure that they're properly worded. Some of our clients go to Google or the World Wide Web to find the language for a non-solicitation agreement, ChatGPT maybe. And what they wind up with is something that does not provide the protection that they need, or it's just so unclearly worded that it would not be enforceable in court. A court's not going to enforce a vague, unspecific, non-solicitation agreement in most instances. So be clear that it does reflect what it is that you want. Also, it properly reflects the nature of your industry today. So, for example, an employee who came to work with you 8 years ago, and you've acquired 3 divisions since then, you're doing different work. Make sure that non-solicit addresses the work that you're doing today. It's a good idea to think seriously about a covenant to return property at the end of employment. And if you have a person in sales, for example, make sure that they're returning customer lists, communication with customers, and that they do not retain any of that information. A good return of property provision will help. If you can't prevent the person from competing, at least you can prevent the person from having this knowledge. You may also consider whether or not employees can be working on their own personal devices as opposed to a company's laptop, which is another way that you might be able to control this information. Um, think about employment contracts. We do favor, whenever possible, employment at will, which means you can terminate a person's employment for any reason or no reason at all, provided that you're not breaching any statutory right that an employee has. But at the same time, you may think about using employment agreements to further encourage people to stay in the job, especially in light of non-competes marginal existence going forward, but a good contract might motivate a person to stay with the company. And then last but not least are the arbitration clauses. Um, Arbitration has many advantages over litigation in court. One of them is controlled discovery, another is predictability in terms of scheduling, and the third is the confidentiality of the process. It's something to think about and weigh the pros and cons of arbitration agreements. Let's go now to our top 10 list. This is something that Catherine and I try to do in most, if not all of our webinars, because we want to give you some highlights, some good takeaway points going forward. So Catherine, could you kick it off with the number one?
Absolutely. Thank you, David. So number one on our list here is the notice requirement. Don't forget to send out the notice. You can send this out today if you'd like to. Just make sure that you do it prior to the rule's effective date, which again is September 4th. I do suggest using the model language that the FTC has provided. There's no reason to reinvent the wheel or overcomplicate things for yourself. And lastly, on this point, before we jump to the second point, as David had mentioned, obtaining an acknowledgement of receipt from each employee that you give the notice to is really an excellent idea. And it is important to keep that as part of the employee's personnel file so that if you ever need it going forward, you know exactly where to find it and you have proof that you met that notice requirement.
Thanks. In terms of tailoring and non-solicitation, make it very clear who this applies to. Not solicitation of current or former employees. Almost always that would be enforceable. If it's not solicitation of customers, define what is solicitation. Now that so many people are online, is solicitation sending an email or reaching out by phone to a customer? Is solicitation going on, for example, LinkedIn and sending a message to a customer or client? Is solicitation going on LinkedIn and telling the whole world you started this new role and this is what you're doing and you're open for business? Decide what it is you want to have for the non-solicitation and update your language accordingly.
That's great. Thank you, David. Third on our list here is review pertinent state law. I'll be brief on this one, but the most important take-home message here is that employers must abide by the stricter standard.
Right, thanks. As Catherine mentioned earlier, there are exemptions under the FTC's rule. We've got the senior executive, a bona fide sale of a business, or when the cause of action accrued prior to the effective date for the final rule on the ban. But identify those exceptions, but please keep in mind that in some states, there are no exceptions. And then last but not least on this slide is plan ahead. And while there is uncertainty about whether or not the final rule will last or survive if there's litigation, and I appreciate the pressure that puts on you, this is a great opportunity to look at your agreements and see if there's a way that you can give the protection your business needs through non-solicitation and some of the other things that we talked about, so that you get protection and you don't have to worry about whether or not the FTC's final rule stands.
Thanks, David. Speaking of uncertainty, it's important to keep an eye on developments. There have been multiple legal challenges already brought. The FTC arguably lacks statutory authority to enact these kinds of broad substantive rules. And we may have some updates as soon as later this summer. So please keep your eyes peeled and ears open with respect to potential developments. Next, we have garden leave. The FTC acknowledged that garden leave provisions are not non-competes because they are not technically a post-employment restriction. David spoke a bit about Massachusetts, and Massachusetts has garden leave clauses. And this is when a worker is still employed and receiving the same total annual compensation and benefits on a pro-rata basis while they are not performing their job. So garden leave remains unaffected by the FTC's new rule. I know we're running a little bit short on time here, so we'll kind of breeze through these last three for you. Number 8 is employee retention. I wanted to just briefly discuss the impact that non-competes have on employee retention and engagement. Overly onerous non-competes might encourage employees to not want to work for you. This is especially true since most employers will be carefully following the ban. This is just another reason why tailoring your non-solicitation agreements may be a better way to protect your legitimate business interests without unduly curtailing competition.
All right, thank you so much, Catherine. I'll hit the last two bullets here. The first, in California, I'm not going to repeat what I said before about how the California law will govern agreements that are drafted by an employer-employee in another state. But know the states where your employees are working from. One of the impacts of the pandemic is so many people are working remotely, and they may be in different states than where your main office is. And if that's the case, take the time to know what their rights are and in those states, not just for non-competes, but in other areas as well. And then last but not least, the business goals in cases. What you want to do is really define what you need to do to protect your business if an employee leaves. And you have a right to protect your business and a responsibility to protect your business. And how do we blend that protection with your obligations under the law? That's a discussion to have internally, and you may actually want to bring in counsel once you come up with some ideas on what you want to do. So with that, thank you all so much for attending today. If you've got ideas for other topics you would like us to cover in webinars, please let Catherine or me know. You can reach us at the information provided on the slide. We love doing these programs to give you an idea of what's going on and help you plan and navigate the choppy waters that is employment and labor relations. Thank you again for attending today, and have a wonderful, wonderful day.
Thank you.